Hi, everybody. This is a little analysis of the Supreme Court decision, along with a look back at the prediction I made. So, when I last did a prediction for Brexit, what I said was to look out for the dates, the 19th, the 20th of September. Now, at that stage, I wasn't quite sure what exactly that date would represent, but um, on the 19th of September was when the court case in the Supreme Court began, of course, sponsored by Gina Miller and John Major. And it was their court case to stop the prorogation. They were, of course, successful. So I want to just look at the ruling and give my opinion on that. And I'm also going to say to you that I think that there were two underlying objectives to this. It was not just to get the prorogation stopped and get everyone back to Parliament. I think it was also the Remainers flexing their muscle in the Supreme Court, trying to regain the initiative. Because since Boris took over from Theresa May, I think all the wind has been in the Brexiteers' sails. So I think the Remainers wanted to gain the initiative again and also test out to see how far they could push the Supreme Court. And I think they will be extremely emboldened by the fact that the decision was 11-1, because Remainers now see that they can take things to the Supreme Court, get a good result for them. Even though I don't feel this result was that significant, it's not a game changer. I don't think anything has really changed. But what's changed is I think the Remainers know the Supreme Court's on their side. A little sideline conspiracy. I think that what this court case also did was distract attention from the Labour Party conference, which was the most hard left socialist agenda Labour has put forward in many, many, many years. Some of the things that came out of there, which I will look at in another blog, are quite shocking. And I think this totally took away attention from that, which was kind of encourages people to take their eye off the ball of what's actually going on with Labour. And I think a lot of Labour voters need to go and have a strong look at what was actually being said there, because the direction of travel won't suit everyone who's traditionally associated with Labour. It's very hard left. And as I say, the news media didn't really cover a lot of what came out of there because of the Supreme Court ruling. So, as for the Supreme Court ruling, legally it was quite tight. Where I think there's a weakness is in paragraph 56. That's where the judges look at the facts, and they have rather gone away from the facts and they have speculated, which they shouldn't. So the way they speculated was to say that even though party conferences usually happen at this time of year and usually take about 3 weeks out of the parliamentary calendar, bearing in mind they last 4 days and they never sit on a Friday, the Supreme Court speculated that perhaps Labour and the Lib Dems may have wanted to postpone or not have their conferences and rather sit in Parliament. But there's no hard evidence that anyone on those parties was going to either collude together or discuss together stopping the party conferences. Now look at this. The party conferences are planned long in advance, maybe 6 months in advance. The venue has to be booked. Everyone buys tickets to it. All the arrangements are made. People plan their transport. People plan their hotels. Everyone who is going to have a stall at the event books their stall and pays for their stall. So a lot of money is paid and deposited. If you call off a conference, there's a big problem in terms of getting everyone refunds, and just kind of it's a bit of a mess, really. You know, it puts a lot of people out. It puts a lot of people's plans out. So to cancel a party conference is a very big thing. Wheels would have had to have been set in motion. Letters would have had to be sent out to let everyone know. And the judges didn't look at, was there any actual evidence that the party conferences were going to be abandoned? No, they just speculated that it might have been an avenue. And I don't think that speculation is a good enough reason. There needed to be strong facts that party conferences were in motion of being abandoned or cancelled or in some way downscaled so that the MPs would rather sit in Parliament. And as far as I'm aware, there's absolutely no evidence to that. In fact, we saw that the Labour and the Lib Dem conferences went off totally as usual. So obviously there was no plan to abandon them. And therefore, the judges shouldn't have been speculating. And paragraph 56 is thus very iffy because it's not based on an actual fact. And in fact, it was only, I think, on Twitter last week that suddenly Remainers were putting forward this, oh, well, they might have been able to cancel the conferences and sit instead. It was all a might have scenario. There was no evidence. So that was a little bit shaky. The next thing was when the judges pontificated on whether this prorogation was too long, being 5 weeks. They only heard evidence from John Major, who said that it was sort of 6 to 8 days was enough to put forward a parliamentary schedule for legislation. He said that they only took his word for it. Now, although ministers don't usually appear in the Supreme Court when there's a ruling like this going on, a judicial review of a ministerial decision or an executive decision, in this case, I think it would have been appropriate for a minister to go in court and set out why, under the circumstances of Brexit, when there's going to have to be an avalanche, an unprecedented amount of legislation put forward in order to enact Brexit, to repeal all the European laws, and to set forward the way, set a path forward, the parliamentary agenda is going to be extremely full, and therefore the normal 6 to 8 days required to set forward the agenda, Queen's speech, could potentially be much longer due to the weight of legislation to do with Brexit. So therefore, I don't think it was enough for John Major to just say, in usual circumstances, it only requires about 6 days to set forward a parliamentary legislative curriculum to be passed in the Queen's speech. There was definitely an argument to be made that because of Brexit, they needed much longer to prepare all the legislation, and that 5 weeks under these scenarios is perfectly acceptable. The government should have fought harder to put that forward, and I think the Supreme Court judges should have been a little bit more open-minded in looking at the facts as we find them right now with Brexit, and not just taking John Major's word. So the ruling is also a little bit weak there, because it could strongly be argued that 5 weeks is perfectly reasonable given the situation right now for preparing the whole parliamentary agenda for the Queen's speech. I would also like to say what the judges said was that prorogation is justiciable, but a dissolution of Parliament is not justiciable. So what they mean is it's okay for them to rule on the legality or so forth of a prorogation, but if Boris just dissolved Parliament, Parliament is dissolved before an election, and it's dissolved, and MPs cease to be MPs, and they have to be returned in the election. So I'm wondering if this means that if Boris actually just dissolved Parliament, that they wouldn't be able to take that to the Supreme Court, and that would trigger a general election. So I'm very interested how that would work. If anyone has any further thoughts of that, I'd be interested to hear, because if the dissolution of Parliament is not justiciable, then if Boris dissolves Parliament, they can't take it to the Supreme Court. MPs cease to have any power, Parliament doesn't sit, and there inevitably has to be a general election, regardless of whether MPs voted for it. I'm just interested in how that whole scenario would play out. So that's my idea on the ruling. I think it's rather suspicious that it was 11-0 in terms of the Supreme Court favouring. Hi guys. Hello Vidosa. You and the one guy said 9 of the EU. Hi Lisa, just switched on. Hi Vidosa, good to see you guys. I hope the reception is okay, because I had to work from this computer because my other computer is not running Google Chrome at the moment, so I won't bore you with the technical details. Boring, they bore me too. Yeah, so I do think it was a bit suspicious. I mean, 11-1, and I think it's clear that the establishment is pro-Remain, so it wouldn't surprise me if all these judges are pro-Remain. A point that was raised by certain ministers when people were questioning, Brexiteers were questioning the Supreme Court, and there was a question of whether Boris would accept the decision. They said that it would go down badly with Conservative voters if the government or the powers that be did not accept the ruling and go with it, because they say Conservative voters are generally pro-establishment, and the Supreme Court is part of the establishment and therefore is above reproach and should be. Establishment is pro-globalist, pro-neoliberal. At the moment, because of the long march through the institutions of the progressives, Conservatives can no longer be assumed to be pro-establishment and can be assumed to be respectful necessarily of the Supreme Court. I think Boris quite rightly has pitted that as the people against the Parliament and the people against the institutions, because that is the exact spirit of what most Brexiteers feel. And I also think that why should the Supreme Court be above question, above reproach? We should be analysing what they do. Who will guard the guards? There can be no one that is totally untouchable, including the Supreme Court. I think it's totally valid to the vote, to scupper the referendum. And it's becoming more and more clear that it's not really that the establishment or certain MPs are trying to secure a deal. They are trying to secure no Brexit, and anything else is just simply saying the wool's being pulled over our eyes. I'm going to come back log with a kind of prediction for where we go next with Brexit. So watch out for that.